A very warm good morning, everyone. Myself, Varnika Verma, a final year student from Chanakilo College, Kumaon University, Uttarakhand, and I am the moderator of today's webinar. I welcome you all in today's international webinar on Trademark and Trade Secret organized by eJustice India. eJustice is India's leading online legal portal which is dedicated to law students, lawyers and attorneys. Its aim is to provide education in Indian legal sector. The portal of eJustice India provides legal news, articles, blogs, case summaries, and also provides certified courses at a very nominal fees. Approx 100 plus campus ambassadors from various law schools across India are working with eJustice India, and I'm so proud to say that eJustice India has been ranked 39 in list of top 100 law blogs and websites of India and is still climbing the ladder. Before moving ahead, let me introduce you with today's topic, trademark and trade secrets. They are not alike at all. It is true that both are valuable assets that gives one's business an edge against rivals in markets. However, their scope of application covers totally different areas. Trademark includes any color, symbols, graphic letters, shapes, etc. that gives the product a unique identity. They are in public domain to help consumers identify the brand and product. They come in handy to create a strong and loyal customer base and to set the product apart from similar goods. Whereas trade secrets basically means that any information that is sensitive to a company's operation and must be kept confidential for its business interests. That will constitute a trade secret. The value of a secret is derived from the fact that it is not open knowledge. I have introduced you with today's topic. Rest, our keynote speaker, Advocate Nabendu Bhattacharjee from Bangladesh Supreme Court, will provide us with in-depth knowledge about the same, whose presence we are humbly grateful for. In 2018, Sir had participated in World Intellectual Property Forum in Delhi and in 2019 participated in IP Gorilla Conference in Dubai and was awarded for his speciality in both the conferences. In 2020 also, he was a part of Russian Ancient Legal Association RALA conference and was honored with the certificate in intellectual property law. At present, our honorable speaker is an international patent and trademark attorney and is a board member of Russian Ancient Legal Association and also associated with Intellectual Property Association of Bangladesh. He is also a member of Bangladesh Intellectual Property Law Society. He has always intended to solve all kinds of critical intellectual property related issues. Sir, it's an honor to have you here with us and not taking much time of yours, I would like you to please enlighten us with your presence and knowledge. So please.
Good morning, all of you. I think, am I audible? Uh, am I audible, I think? Varnika, am I audible?
Yes, sir, you are audible.
Am I audible?
Yes, sir, you are.
Varnika, am I audible? Am I
Yes, sir, you
audible?
are. Yes, sir,
Okay.
yes. Sir.
Okay, good morning. Okay, good morning, all of you. Firstly, I congratulate today's our moderator, Varnika Verma. And I heartfelt congratulations to all of the viewers and also who will be viewing this YouTube channel in future. I will also thankful all of you and especially Mr. Robbie and his brother who will actually insist me, who will actually invite me for present this honorable audience. Thank you, all of you. Actually, our today's topic is trademark and trade secret. If I simply go through the trademark and trade secret. I actually operate such this slide. Firstly, I introduce what is the trademark, what is why we will go to trademark, how much, what is the type of trademark. Then we will go to the trade secret. Then we will define and after all of the slide, then we will also if there is any queries for the students or there who are present there. Obviously, I will try my best to solve such kind of question is there. Okay, so I think the moderator, you please start whenever one by one slide. Actually, I am Nabendu Bhattacharjee from Bangladesh Supreme Court, and whatever the Varnika introduce myself, I is not like that, but I always try to gather knowledge about the trademark law. I believe still now I am the student of trademark law, and always I think to try lots of knowledge about the trademark law. Actually, what is the history of the trademark? Trademark trademark have a long history. This back to the ancient time. This is not actually that trademark is starting 100 century ago. Not like that. It's past. If we find that it passed in the reached the region on the 12 century 12 and 66 by the King Henry III, which required all bakers and use of distinctive mark for the bread they sold. The first modern trademark law emerged the late of 13th century, I think. Uh, Please go to the second slide. Second slide. What is the trademark? The primary purpose of the trademark law is to prevent unfair competition by applying the test of consumer confusion and providing right and remedies to the owner of the trademark. What is the primary purpose? Primary purpose is that if we think that I have a trademark, so primary purpose is that the registering of trademark is to prevent who are trying to passing of my trademark to prevent the unfair competition from that. This is the primary purpose. After all, I will go to the elaborate purpose of that. But primary is that to prevent my right, my intangible right of trademark. Secondly, if we think what is the TM? TM just means trademark. Trademark is a sign. I think I will go to the second slide. Uh, Second slide maybe. So I think what is the TM? TM trademark. Trademark is a sign or symbol. Any individual word, letter, number, drawing, picture, shape, color, logotype, or use the differentiating commodity of service may be considered as a trademark. What is the trademark? Trademark is a symbol, like a very symbol. It's a trademark. If we think that a letter A, B, C, D, it's a trademark. Number is a trademark. A drawing is a trademark. Maybe I have a picture. Art, it's art by X, Y, Z. It will be trademark. One color. Color also be treated as a trademark. Shape also be treated as a trademark. But there is a point. Point is that uh, some countries, if we go to the territory of our in Bangladesh, we have actually still that we are not enforcing such kind of color or shape or any sense. This is not permitted in the law of our countries. But in abroad, lots of countries have a law to register the color or scent or on a symbol. Now we come to the second slide. If think slogan also the trademark. Advertisement are considered also the different countries. If it refers different between the product or service from the organization to another organization or owner. A trademark is a guarantee by the quality and indication of source. This essential product of trademark is to suggest the origin of goods. Yes. So always, if I think that I have a trademark, so if I register my trademark, it is the guaranteed that my trademark is that it is owner of mine. It is not the another's. It is mine, and it guarantees the quality. Whenever someone registered his mark, it's obviously guaranteed his mark that yes, it is a quality mark. It has a quality. So any purchaser can buy it from any market. That is the quality. So what is the type of trademark? Before that, actually, trademark is divided in 1 to 45 class. Who is the authority? Authority is the NICE classification. By NICE classification, trademark are divided in 1 to 45 classes, whereas 1 to 34 are goods, and 35 to 45 are fall in the service. What is the service or what is the goods? Goods maybe there is a mobile phone. There is a mobile phone. It's a goods. There is a pen. It's a goods. And maybe there is a pillow. There is a computer. There is a laptop. All are fall in the goods, and all will fall in the 1 to 34 classes. The rest of classes are for the service classes. That's mean if we think I have an hospital. If I think that I will go to register this name, it will be the fall in the 35 to 45. A school will provide the service. That's mean on I think if a software provider company, they think, if we think that they will register their mark or their program or the title, obviously it can, but this will be fall in the 35 to 45 classes, as because those are in the service classes. Now come to the what is the type of trademark. What are the type of trademark? A trademark may be divided into following classes, whichever is the visual in the our today's slide. One is that firstly word mark. Word mark may be word, letter, or numerals. A word mark gives the proprietor a right only the word, letter, or numerical. No right is sought with the respect to the represent of the word. So what is the word mark? Word mark, actually my slide is before that. Before that, I don't know what is the what number of slide it is before that. Yes, this is the slide. Word mark is a letter mark. If we for example, my company's name is uh, my company's name is Istikutum. My company's name is Hawkins. My company's name is Samsung. If I write, it's a Samsung. If we write is likely word, not any device, not any color, not any style, that it will be treated as a word mark. Now come to the second. What is a device mark? Where the trademark lies in a unique representation of a word, letter or numerical, it will be a device mark. Actually, word mark and device mark likely the same, but different is that device mark is will be a unique representation. Whenever in future, after getting the registration, if someone, the owner of the trademark, think that yes, they will use this device mark in their advertisement or any other papers or office, he always use that device mark in the unique representation. But in the word mark, maybe Samsung, SAMSU in Samsung. If it is word mark, he may write it in capital letter or small letter, whatever it is. It always will be the word, but there is no any shape. And its limitation, it is not limited under the shape. It device mark, it's always be limited under the shape. What is the shape? Guaranteed by the trademark registry by getting the trademark certificate, it always will be the same shape. What is the registered? Then come the service mark. A service mark is nothing but a mark dash distinguish the service of the person from that of another. Service mark do not represent the goods, but the service offered by the person of company. Yes. What is the service mark? Service mark is that very kind of mark. Whatever always provide the service. My pen name is X pen. It is his name. It's not provide its service. Service name is maybe I have a office. I have a law firm. I have a law firm. Law firm name is ABC Associates. For example, ABC Associates. What is the purpose of the law firm? Law firm purpose is to provide the law service, law advising, advise the law someone. So their service, they are provide the service. So in which company, which office, who provide the service, they are called the and try to obtain the registration certificate. They are always fall in the service class. Service mark. They are used in the service business where actual goods under the mark are not treated. It is a mechanism of available to protect the mark use the service of industries, does business providing the service like computer or hardware or software assembling and maintenance, whatever I told you. Now, please come to the next slide. Next slide, collective mark. If we go to the next slide, we'll find that it's the collective mark. Collective mark is very important. It's a very important. Marks being used by a group of company can use. I think, please, Monica Verma, please go to the next slide. Varnika, please go to the next slide. Yes. Now collective mark. Mark being used by a group of companies can now be protected by the group of collectively. Collective mark are used to inform the public about the particular feature of the product for which the collective mark is used. The owner of the such mark may be an association or public institution or cooperative. Collective mark are also used to promote the particular product which a certain characteristic specific to the product is given in the region. Example, maybe XY is a company. Maybe XY is a company. It has XY cement, so XY ceramic, XY garments, etc. The main collective mark, what is that? Maybe one, if we go to the simply elaborate, there is a company. This company have lots of subdivisions. Maybe it's a multinational company. It's have lots of sister concern company. So what is the collective mark? Collective mark is that my company produce the cement, my company produce the ceramic item, my company produce the garments item, whatever it is. My trademark is XY trademark. I use it in case of cement. I use it XY cement. In case of garments, I use it XY garments. In case of ceramic, I use it XY ceramic. That means mark is individual. This is for my company, and I can use it. Whatever produced by the company, I will use that very kind of mark. This is called a collective mark. Now, certification. Certification mark are used to to define the standard. To define the standard, they assure the consumers that product meets the certain prescribed standards. The presence of a certification mark on a product indicate that the product has successfully gone through the standard test specified. Certification mark. Actually, it's a very important for the buyer. Certification mark is that very kind of mark which is guaranteed, which is tested by the standard that okay, this is a standard tested mark specified by the specified, and it is always successfully gone through the mechanism that who is granted the standard. If we also easily elaborate that I have a mark, I registered it from my our trademark registry office. This is not end here. It will be also another process. We have to guarantee. We have to taking the guarantee from the tested specified by such other office who is specified such kind of tested that yes, this mark is guaranteed by test. So it will be the certification mark. This means certified by the standard. Certified by the standard is called a certification mark. It is assured the consumer that the manufacturer have gone through an audit process to ensure the quality of the product. It always ensure the quality the product of that very kind of trademark. For example, toys, electrical good, etc. have a always have certification. Now come to the well-known mark. What is the well-known mark? Well-known, when a mark is easily recognized among a large percentage of the population, is achieve the trademark status of a well-known mark. Well-known mark enjoy greater protection. Persons will not be able to register or use mark, which are imitations of well-known trademarks. Well-known trademark simply it's a very simple that well-known trademarks is that very kind of trademark. It's well-known by uh, all the consumers, all the territories, all the around the world. It's a well-known mark. Samsung, it's a well-known mark. Amazon, it's a well-known mark. This means the mark which is well known from the person is a called well known mark, and it is always secured the standard to granted to registered for every territory of the world. This is called the well known mark. It's a easy to get registration for in every territory if they are owner of the mark thing. It's always possible. Now the unconventional trademarks. Unconventional trademarks are those trademarks that get recognition for their inherently distinctive feature. Now we come to go to the next slide. Unconventional trademark. Unconventional trademark are include the following categories. Whatever I describe now. Color trademark. If a particular color has become a distinctive feature indicating the goods of a particular trader, it can be registered as a trademark. What is the matter? Color trademark is limited in a particular color. It's become always a distinctive feature. Indicate the goods of a particular trades. What will be the example? Example is maybe red wine. This will be the example. But color mark is actually not whatever I think color mark is not granted by all the countries. For example, in Bangladesh, we are not go to the such kind of we have laws, but our trademark registry still that they not register such kind that is a color mark. Abroad, lots of the country in the abroad still now register the color mark, but Bangladesh is not. Sound mark. Sound mark also a trademark. For the seasons, they are called the sound mark, shape mark, smell mark, color mark. It's unconventional trademark. It's because this is not those trademark are not availability registered by all the countries. Now the sound mark, sound sign which are prescribed by hearing and which is distinguishable by that distinctive and exclusive sound can be registered as a sound mark. For example, musical note. This means I have a music. It It is a unique music which is registered my band. No, I have a band party. I have a band. I have a I have lots of musician. I have a studio. I have a unique song, unique music, which is only for mine. If we go to the for things, if we go to train, if we go to if we go to train, in every train we found that sometimes we found in our country also there or the abroad another country of the abroad in train journey. Sometimes we found that there is a exclusive sound for this train. That's mean the train is go to the next station. Next station is Calcutta. For example, next station is Calcutta. So it is available in our Bangladesh. For things, next station is Calcutta. So when train will be arrived, there is a sound will be published. Will be sound that one music. This music think that this is only for railway purpose. This purpose is not for a ship, not for plane, not for by road. Actually, I would like to think, or I would like to elaborate such kind that sound mark is always for a unique sound. This is not for other. This is only for one studio, one musical studio or party there like that. Shape mark. When the shape of goods packaging has some distinctive feature, this can be registered. Shape, it is sometime it's fall in the design also, but actually fall in the design. Uh, there is a distinctive for design and trademark of shape, but shape is also fall in the trademark as well. When there is a goods, it says a shape. Goods is availability in the market. Maybe this goods is produced by the lots of countries, lots of companies in a country. But these goods have such a limited shape. This shape cannot be infringed by any other if I taken registration as a shape mark. What is the example? Example maybe ornamental lamp. Ornamental lamp. It is a dis- distinctive shape. No can possible to infringe, no can possible uh, to infringe such kind of shape. As because I already taken the register, the owner of the shape mark already taken the register as a shape, as a limited as a shape. Now come to the smell mark. When the smell is distinctive and cannot be mistaken for an associate product, it can be registered as a smell mark. For example, the perfume. I have a perfume. This company produce the perfume. It's a distinctive smell. Okay. Lots of company are there who are produce the smell, but they cannot produce such kind of smell which is for my companies. Which is for my companies what is already get registration. Actually, smell mark or sound mark, color mark, it is unconventional. I told it. It actually not guaranteed by all the countries, but lots of countries has such kind of rights or such kind of registration process. Collective mark. Marks being used by a group of companies can now be protected by the group collectively. Collective marks are used to inform the public about a particular feature of the product for which the collective mark is used. The owner of the such mark may be an association or public institution or cooperative. Collective mark are also used to promote particular products which have certain characteristics specific to the producer is given the region. I think our now slide is slide main object of the slide. Yes, main object of the slide. Uh, the main object of the what is the main object of the trademark? The main objective of the trademark is to help the consumer to identify the commodity of a certain company. That may be something like service or goods, so that any consumer can differentiate exactly the same type of commodity supplied by any competitor of the organization. It's the main objective. It's a very important for the trademark. For example, I have a trademark. I have a trademark. This is mine identity. No can possible to infringe it. No can possible to passing of it in a market, as because that is my goods. I already taken the registration of this good. So the main objective, if I think yes, this goods is mine, I have a lots of dream to be. I have a dream to elaborate it. I have a dream to sell it in also market. So I have to provide. I have to take in registration firstly for my trademark. It is the objective and the principal objective. As if I getting the registration of my trademark, no, and there is no will possibility to for any other competitor to infringe it, as it will be registered or guaranteed from the trademark registry of certain countries, and it plays an important controlling role for the branding marketing strategy of reputed product of any organization or owner. If I have a trademark, always I am trying to controlling the branding of my mark, as no can getting a chance to infringe my mark. It creates a goodwill also. The goodwill, the image and positive concept of the particular product in the eyes of the consumer of the buyer. So it's a main objective actually. A well-known trademark is the most valuable business property. Trademark is the most valuable intangible right. It's a right, and it's a most valuable intangible right for the purpose of the business. So the main object of the trademark main object of the trademark is that the branding, the goodwill of my mark. So always one person have to think to register his mark. So maybe come to the if we go to the next slide, we found that uh, what happened. If we go to next slide, we found that what happened if I cannot restart my mark. Yes, what happened if I think okay, I will not restart my mark. If we assume that a certain company has been doing a very good business in the market, but if that company does not register its trademark, its business goodwill and investment may be in the vain. So registration of the trademark is the must for a company. A well-known trademark is the main controlling to determine the market price of any commodity or service, and for the registration of the trademark is very urgent. It's a very urgent for any business purpose, for trading or business purpose, is to taking registration for such kind of mark. This is mine mark. Maybe I am a mark. I have a mark, but I do not go to the trademark registry for registering purpose. But this mark is a very goodwill in the market. Yes, everybody is we to always think to intimate my mark. It's because people of as we are the human man, we are always trying to growth of our business, and always we are try to controlling power of our business is us. No one can think that okay, this is my business. The controlling power will be another hand. No, nobody can think it. So if we always try to controlling power of our business is mine end, our end, owner end. So always it is it should be registered of his or she's mark for the registration purpose. No can if any other person get a simple chance, get a simple room, he obviously think to intimate it, passing of it. So if we did not go to restart purpose of our trademark, there is a lots of chance to goodwill of the pain of the goodwill of the mark. So we always should to restart our mark. Now come to the main point: difference between the registered trademark and unregistered trademark. It's yes. This slide. Difference between the trademark and unregistered trademark. A registered trademark confers a bundle of exclusive rights upon the registered owner, including the rights to exclusive use of the mark in relation to the product or service. Registration of trademark is not a mandatory requirement in India actually. Mandatory requirement. Not only that in Bangladesh. I will come in the later. A trademark is registered for a period of 10 years and is subject to renewal. The trademark in 1999 governed the whole. Yes, registered trademark. The registered trademark can be obtained relief in respect of infringement of the mark in any area of the world subject to the registration is mark of the said territory. Yes, if I think that yes, I registered my mark. So what will the result? Result is that this mark can exclusive right upon the registered owner who will taken the registration of this mark, and it including the right of exclusive use of the mark. Its use exclusively in mine. But point is that no, you will not bound. No can influence you. No can pressing you. You are not bound to restart your trademark. Yes, you have a good success, you have a goodwill, you have branding, you have lots of market behind your mark, but you are not bound to. Nobody can press you. You are not bound to restart your mark. Why? Why come to point? Trademark clause not exclusively bound someone, exclusive pressing someone that yes, you have mark, you have to restart your mark. No, this registration is for mine, for business owner. So if we always think that this mark is very, very important intangible mark for mine, so I always go to the process of registration. So in case of Bangladesh, actually, the registration process is for first time when we got the registration certificate, it will go for the 7 years. Then in every 10 after expiring the this mark, it that the limitation of the guaranteed time, we always try to by giving the prescribed government fees, we will get the limitation period of this mark for the next 10 year, and simultaneously and every kind of every time whenever we give the prescribed government fees, it will be always for the every 10 years. Now unregistered mark. An unregistered mark is an unregistered trademark is one does not possess legal benefit. It can still product by the means of common law of the court of passing off. Yes, a registered trademark. If I registered my trademark, who will give me the lawfully protection. That yes, if I restart my pen in the market from the trademark registry, this is my mark. So who will get the protection? That very kind of laws, trademark laws, guaranteed you that yes, if someone infringe your mark, trademark law has there to protect you. But if I have an unregistered mark, have I any guaranteed to protect the infringement of my mark? Yes, I have also the right. If someone think no, I will not go to I will not go to trademark registry for taking registration of my mark. So I no, I have any laws. Yes, I have. I have a tort in the which in means of common law tort passing of can be guaranteed by the law of tort. Though the point is that the law of tort is not commonly used all over the countries, like our South Asian region, if think in Bangladesh or India, tort law is not vastly used. So the exclusive protection of the mark we have to taking the registration certificate. Registration. So what is the trade secret? Now come to the our today's our another part is the trade secret and trademark. Now come to the trade secret. If visually, if the audience clearly visual slide, you found that there's a cross mark in this slide. Actually, when I wrote it, I think though it's a trade secret for these reasons, I have done as a cross for that. It is secret. Actually, what is a trade secret? Trade secret are type of intellectual property that comprise the formulas, practice, process, design, instruments, pattern, or complication of the information that have inherent economic value because they are not generally known or readily ascertainable by the others, and which the owner takes reasonable measure to keep secret. Trade secret, if think I have a recipe, I have a method, but still taking the registration, this kind of recipe in my in my head, and I wrote it in a paper. This is a secret. No one can know. I will go to the registration purpose in future. This recipe secret is mine. This is called a trade secret. Now come to the example of the trade secret. An example is a trade secret is the recipe or formula. This cooker, there is a cooker, or I cook, for example, XYZ cook a very tasty food on cake, on a bread, on a sweet. XYZ may may cook a sweet. What is the recipe of the sweet? If anybody can cook one item, and the um, hotel of this the customer of the hotel very impressively taking such kind of cook, that is a tasty, but there is a secret. There is a secret of the recipe only knows by the cooker. No one know the none know the recipe secret, only the cooker know. So it is the trade secret of the cookers. If the cookers wrote it in the paper, in the daily gazette, or in the time of gossiping he told it some XYZ, this is the recipe of my cooks. Yeah. So some XYZ open a hotel in another town and receives such kind of goods, customer will go that kind of hotel. My hotel business will be go to vain. Why? As because if I don't getting the registration of the trade secret, trade secret is the very important part also. Trade secret is the very important part in every business. Every business, the owner of the businessman has a secret information which is in his head, is his mind. So it always controlling the owner of this business. So none can be delivered his write down his secret, trade secret in the paper. At present time, consumer or the buyer have earned awareness of some extent regarding trademark or trade name. Nowadays, we see that buyer purchases certain commodity depend on the goodwill or image of the trademark and the desired quality standard of the product. Even the price of the product is high. Yes, this is and understanding the opportunity of the designer businessman always try to apply the infringing of the registered trademark. So simultaneously, if I have a mark, I have to register my mark as a trademark as a secret trademark. It is the businessman always the duty for the businessman. Now come to the if I go to another example, this is not written in my slide. This is not written in my slide. If I go to another example, uh, now how we can protect our trade secret? I have a trade secret. I think yes, by depend on this trade secret, I enlarge my business. I have a goodwill. Depend on this trade secret. So generally, the owner of the trade secret has to rely on the relevant provision of the national law. There is national law and for protecting the unfair competition by the court under the law of tort, by the guaranteed by the law of tort to protect your trade secret. It's not available in all countries actually. Those countries who has availability, who has a protection, who has a existing laws of fraud, that very kind of jurisdiction of the country always guaranteed by the trade secret, by the trade law, by the trademark registry. Now come when we write TM, SM, and R. Is the market. Lots of product. If we go to market every day, we found that there is a product. There is a product. The corner, top corner, in the right side, there is written as a TM, as a R, as a SM. What is the differentiate between the TM, SM, and R? TM, SM, and R is a symbol. TM means trademark, SM means service mark, R mean registered. Now, I have taken the registration of this pen, of this name of this pen. So what should I do? I have to write an R, symbol R, in the right corner of this mark. By putting R, all of the infringers who are in the market understand that this mark is already registered by that jurisdiction. So no one can have a chance to infringe it. By putting R, that means I announce all the traders, all the infringers that my mark is already registered as I putting here R. If someone wrote SM, right, SM in the right corner of this mark, that means this mark is as a service provide mark, service provided. SM is service mark. And if someone write a TM in the corner of the mark, it's the trader or the infringers should to understand that this mark trademark is the registering process. already filed an application but not get the registration. It's the registering process. In that kind of time, after filing a trademark and before getting the certificate, the middle of the time, during this process, we always can write TM. That's mean my mark is on the process of getting a certificate. The businessman or other understand is to use this symbol. In the consequence, the dishonest businessmen abstain. The dishonest businessmen who are available in this market, they can abstain for imitating the trademark by writing TM, SM, and R. So we always try to write the SM, R, and TM. Before go to the slide, when we write TM, before go to the slide, I have another elaboration is that the present business, it's the age of business, it's the age of technology. For this age, we have to restart our mark for promotion our business, promoting our business. That's because nowadays it's a very important mark. The market is Amazon, Google. What is for Google? Is a trademark. Is it for technology? Apple technology, Microsoft technology, Samsung Group technology. These are the valuable mark nowadays in the country. The necessity of the registration trademark is the infinity, and they differentiate to their owner to controlling their business in their own. No can have a purpose to registration their to increase their mark if they wrote SMR and TM. Now the we why the student uh, wh- uh, why the student should be uh, uh, is if it possible to enlarge this slide. Yes. If is yes. At present, the age of business and technology, the student needs to know the IP law. It is a required not only the studying purpose, it is also necessary for other things which are mentioned below. Now, why the student need IP? Yes, I am businessman. I need IP. I know no ideas because I am lawyer. If I think this is IP law is not IP law is for me. No, student have no idea about the IP law. It's because how the developed countries will sell the good registered by the trademark and how they will earn the foreign exchange. So, if I am a student, I am in the final year, and after completing my study, I will go to a market. I will be a businessman. So, whatever I go, I always know that what the purpose of the registration. If I have business, I always think to know the purpose of the registration. Whatever lawyer are there, we are lawyer are there to protect your mark in the market. But why you have not know? As a student, you should to know. Now, how second is that how the technology will save the businessman from deceitfully work through the trade secret. Yes, maybe after I am a student now. After completing my study, I will arrange a business. I have an office. I appointed some two or three business associate staff in my office. I have a staff in my office. I always maintain my office as a CEO of my office. I am a MD of my office. I am CEO of my office. I have three staffs. For example, I have three staffs. I have a new idea in my mind every day for enlarge my business, for expanding my business purpose. But I always share my idea to the staff. I have a staff. I share with him that I have such kind of idea in expanding my business in my office. After that, he taken a resign from my office. He's joined another office. What will be should? What will be the that purpose? The result is that when the staff of mine resign my office and join another office, he will share my test. No, no, this slide is yes. This slide. I have a staff. He resigned my office and go to another office, join another office. I share my trade secret with him. Then such staff share my trade secret with his new office. What is the result? Result is that my idea go to the brain. So if I should know about the trade secret, I did not share my trade secret to others. Now come to point number three. How the own country's good can be sold to other countries through licensing by taking trademark ownership. Yes, is the trademark law. There is a licensing. Maybe I have a registered trademark, and it's a lots of goods. I think that my goods will be sold in the behind the jurisdiction of my countries. I sold my goods in the another countries. So I have a taking licensing by the trademark of the ownership. Student should know how the trademark. Point number four is that how trademark ownership can be leased for a certain period for the licensing. Yes, it's also important as a trademark. In the trademark law, we have a trademark may be leased. Trademark. I have a trademark. I lease this mark as a use for another one by licensing trademark agreement. It can possible by the trademark. So it can earn. For example, I have a trademark, but now it's not possible for me to expand my business, to carry on my business, as because I have no lots of money in my pocket to expand my business. I getting registration of my mark. So what can I do? Before, though I have no ability nowadays, the ownership have no ability to expand his business. He are going to close his business shop. What can do? He can licensing. He can list his mark by a licensing for a certain period to another, and the owner can get the some price for this exchange of price for this mark. This is called the licensing. Now go to the for now go to for next slide. Yes. Now we came in the concluding mark. Before the concluding finally, this can be said that without the registration of the trademark, investment of the owner of the good may go in the vain in case of marketing the goods, because the competitor of the organization using the same or exact trademark may create confusion among the consumer, which will damage the reputation of the image and business of the financial reputation of the particular company. So the importance of the registration of trademark can easily be realized from the discussion. So what is the realize from our discussion? Our discussion is that I have a trademark. It's a good business. It's a good brand in the market. So always I can register this mark. Importance of the register of my trademark is for the um, expand my business, or granted guarantee of my mark that no can intimate my mark, no can and there is no any kind of possibility to infringement of my mark. There is no any chance to passing of my mark in the market. So the concluding remark, if I think that every people, every student, every lawyer, every lecturer, whatever it is, should to know IP. This is not for us. This is not for business. This is not for mine also. This is not individual. This is for individual person. This is for the business person also. This is for the company also. Individual person is don't know that trade secret. Business purpose is always think to protect his mark by getting registration certificate. Another thing is maybe I did not write in slide. If we found that the someone are infringing my mark in the market, what should we do? We have a in Bangladesh or India, whatever it is, we have a prevailing trademark law, existing trademark law. So by depend of this law, we can send a cease and desist notice to the infringer that you are using my mark. I have a knowledge that you are using my mark, so I am requesting you by sending this cease and desist notice. Please stopping the infringement of my mark unless until we will go to the court for taking the initiative against your business. So I always think to taking the registration of the trademark and as a trade secret, whatever it is, for the purpose. So I think Varnika, there if the audience has any questions, I am ready to answer the questions if there.
No, sir. As of now, there are no questions.
So I don't know how I can elaborate it, how I can describe the audience that the importance of the trademark, importance of that secret. But I always think if any of the audience or any of the visible audience have any question to me, they may write to me for write a questions via email. I always try to send me the answer. And I have a if they think I have I have some paper writing uh, in the Bangladeshi papers and international journal also. If someone think I send it for their past knowledge about the trademark law.
Sure, sir. As all things comes to an end, so is the webinar. On behalf of E-Justice India, I take this opportunity to propose word of thanks to our keynote speaker, Advocate Nabendu Bhattacharjee, for taking out time from his busy schedule and enlightening us with his presence. It was a privilege that we all got a chance to hear you, sir. Today's webinar was full of knowledge and interesting things. It gave deep insights into the topic and also revealed some interesting facts. Altogether, it was a very informative session. I'm pretty sure that the precious knowledge that Sir has given us will definitely help us in our future and in our studies. And my special thanks to the participants for paying their kind attention. Once again, a heartfelt thanks to you, sir. With these words, I would like to end today's webinar. Stay tuned with eJustice India for upcoming webinars, courses, and much more. Thank you. Thank you so much,
Yes,
everyone.
yes, thank you, Barmika, and thank you, the audience, for giving your time to know about me, and I have my giving a chance for elaborate my description regarding the trademark law. Thank you, all of you.
Thank you so much, sir. Thank you.